Juries, and the bias that exists within them, are well-documented phenomena. It's easy for us to identify a few bad apples existing in a society and rightfully work against it. But if bias exists within a system perpetrated by people we're told to trust, like police, judges, and teachers, we're more likely to shy away from discussing or even acknowledging it. I'm sure if you're a person of color, have been affected by the legal system's misdeeds, you're going, yeah, obviously. But the fact is that a lot of people don't even know about the shit that's been happening. That's why I'm making this video, so I can tell people that racial bias exists in a major way in our legal system and nobody's talking about it.
Damn! Did y'all see how far she jumped off the porch?
Every American knows how a jury works. Guy in a wig gets 12 angry men in a room, they discuss, come out with a verdict, bang bang the gavel, and away the dude goes. It's standard procedure, and according to the Supreme Court, the most substantial opportunity that most citizens have to participate in the democratic process. The Sixth Amendment guarantees an impartial jury. But there's a caveat. Like all American institutions, there is a deep, long history of racism. If you're black and you walk into a courtroom and see a jury of white people, there's a much higher chance that you will walk out convicted, guilty or not. You see, not every juror that is selected gets chosen. Obviously, if someone's mom gets chosen to be on a jury, you can assume she won't be fair and unbiased. Optimally, the jury should know and care as little as possible about the defendant and plaintiffs. The process of eliminating biased jurors is called voir dire. It means speak the truth. This can get murky, especially in celebrity trials.
Oh my god! Am I
Homer!
Usually, they can scrap together 12 people that are unbiased. However, even if you are unbiased and likely to be fair, if a judge or attorney does not want you or thinks you're lying, they can use one of their 6 peremptory challenges. The peremptory challenge is the major tool that lawyers and judges use to make a jury more biased and racially skewed, and there are very few restrictions on them. We have tried, though. In 1986, a landmark case, Batson v. Kentucky, made it illegal to use peremptory challenges to discriminate against race, and in 1994's J.E.B. v. Alabama, it was extended to gender. Remember when the Supreme Court wasn't brain dead? Anyway, in Batson, Lewis Powell wrote that, in upholding the 14th Amendment, purposeful racial discrimination in selection of the jury violates a defendant's right to equal protection. Thurgood Marshall, famous chill dude, concurred and went even further. He said that, quote, "The goal of ending racism in jury selection can be accomplished only by eliminating peremptory challenges entirely."
It's not ridiculous. That's not ridiculous to say that.
Side note, researching this, I found out that a dissent was filed by Chief Justice Warren Burger, and his predecessor was named Felix Frankfurter. I don't know what to do with that information. Unfortunately, in Batson, the attempts at eliminating bias don't work as well. There are many loopholes around the Batson challenge, as it's called by lawyers. Marshall has a point. Peremptory challenges are the obvious number one cause of bias because they allow unfettered access by a judge or opposing attorney to affect the outcome of the trial. If a client is a black man and a judge uses all 6 peremptory strikes to make the jury all white, it'll obviously skew the outcome.
Oh no!
A study conducted by Duke University in 2012 found that a jury made up of all white people were 15% more likely to convict a black person than a white person, whereas when at least a single minority was added, the numbers evened out to about a 70% conviction rate. Well, how many all-white juries can there possibly be, you might say? There are surely enough black people in the jury pool to make this issue null. Of course not. This is where peremptory strikes come in again. Jacinta Gao found in a 2016 study that in counties with less than or equal to 50% white people, 62 were majority white and 13 contained no minorities at all. This proves her idea that underrepresentation of minorities on juries is an ongoing problem. Gao also argues that the cause of this could be due to a problem with the selection of potential jurors. The case for ending peremptory strikes appears more and more clear the more you look into it. Though Chief Justice Burger argued that it was a tradition of our legal system, it doesn't make it good. Slavery was also a tradition for 300 years. Peremptory strikes do much more harm than good. Judges should not be able to eliminate potential jurors based on personal beliefs. It undermines the democratic purpose of a jury. There are a lot of serious accounts of harm done by a jury's racial bias. In his remarkable article, Bias in the Box, Dax Devlon Ross highlights some of these stories. One case he singles out is Daryl Hunt's. Hunt was a black man who, accused of murdering a white woman, was sent to prison for 20 years before DNA evidence proved he could not have killed the victim. Hunt committed suicide about a decade ago. The other major case he references is Andrew Ramseur's. According to the NC Coalition for Alternatives to the Death Penalty, Ramseur's trial was incredibly weird. His family was forced to sit in the back while the white victim's family was allowed to be in the front. Peremptory strikes eliminated all black jurors, and media outlets exacerbated the digital lynch mob. Comments called Ramseur vermin and made comments such as, "Where did I leave my rope?"
Kill that boy! Kill that
Ramseur was sentenced to the death penalty after just a few hours of deliberation. An appeal to take him off the death row was denied in 2020. If peremptory strikes were not allowed, Ramseur would have had a more representative jury and a fairer trial. I'd like now to quickly define what the Constitution and the Supreme Court define as a fair trial. The second clause of the Sixth Amendment states that any criminal prosecution should be conducted with an impartial jury. An impartial jury must be made up of unbiased jurors and a fair cross-section of the community. Without impartiality, a trial is not fair, and that case should be thrown out. If a black defendant lives in a county of 80% black people and the jury is made up of 90% white people with a white lawyer and a white judge, how is that fair? According to the Constitution and hundreds of SCOTUS cases since, it isn't. But they aren't treated that way because this is such a niche issue in the eyes of most Americans. So, how do we fix this? Well, eliminating peremptory strikes would be a good option. It's just difficult because so far no states have any plans for how to successfully... What? Oh. Yeah, so apparently Arizona eliminated them 4 years ago and things have been going great since. In a great article, Haley Gordon Badger did a ton of research on this issue and concluded that the functions of peremptory strikes have been being performed in a much more objective manner without them on the table. Of course, this is just a starting point, both for Arizona and the rest of the country. So how can you help? Become involved in your local politics. Unless you're in Arizona, the other 49 states all have peremptory strikes. Vote for people who think they're biased. Educate others on their importance. Protest about it. Support any bill that might be proposed against them. Call your representatives and talk to them about these issues. Talk to anyone with political pull or power. Talk to the mayor of your town. Talk to your state reps. Talk to activists. Make this a more known issue. It is one of the most prevalent forms of systemic racism that we could very easily end.